Hello, everyone. My name is Max Clark, and on behalf of the Fox Alliance, we are grateful that you have chosen to join us this afternoon for our presentation on the Secure Act 2.0. What we're going to be really talking about today is one of the most sweeping new updates to the way that we as individuals will end up saving for our retirements. The Secure Act 2.0 is a follow-on to the original Secure Act, which was passed back at the end of 2019 and took effect in 2020. And I always love the acronyms that our government ultimately comes up with. SECURE stands for Setting Every Community Up for Retirement Enhancement. And I'm sure it took them a very long time to come up with that. But nevertheless, that is what they've chosen to name this. And while the first act took effect back in 2020, this new act was passed in conjunction with the Omnibus Appropriation Bill that was passed there at the end of last year and took effect at the beginning of 2023. So we'll be getting into the details of the changes and everything on that front. There will be three speakers today. Myself, I'm a wealth advisor here at the Fox Alliance. Then Travis Eaton, our CPA here at the Fox Alliance, and then Josh Renfro, one of the managing partners here, will be wrapping things up for us. We will be taking questions at the end of the presentation today. One or two of you guys have already emailed some questions into us, but if you would like to send questions to us for us to answer here at the end of the conversation, we will be doing so through email. Due to the regulatory environment here in our industry, they don't allow us to take questions through Zoom. So in order for you to get questions to us, please email them to Max at the Fox Alliance. You can see that here on the screen. Well, let's go ahead and jump right into it. And we will start by talking about one of the factors or changes in the Secure Act that will really affect everybody on this call at some point. And that has to do with the required minimum distributions, RMDs, and the beginning age at which those will start. The Secure Act 1.0, which passed back in 2019, changed the starting date for requirement RMDs from 70 and a half to age 72. And now with this new act, we are seeing that change again. And there's two facets to this. Starting this year, it has been changed from 72 to 73. So you can see here on the left-hand side, if your birth year was 1951 to 1959, the age at which you're going to begin RMDs is age 73. And that will take effect for really the next 10 years, 2023 through 2032. After that point, starting in 2033, that age is going to be bumped to age 75. So what we're seeing is some changes where they're pushing back the ages at which we are going to be required to take distributions. One important thing to note, this does not impact qualified charitable distributions or QCDs. Travis is going to talk about this a little bit later. But this used to be tied in with the age at which you started RMDs. And effectively, a qualified charitable distribution is making donations to charity directly from your IRA. And you can still do that starting at age 70 and a half. So let's take a look at some of the financial planning considerations here in light of this new change. And effectively, there are two big things to point out. One, this is going to provide more time for us to do Roth conversions if that's something that we're doing or you're doing going forward. Obviously, we wouldn't want to do that, generally speaking, beyond the age at which we're taking RMDs, and this will push that time back. And then also, once RMDs do start, because the age has been pushed back, that distribution percentage is going to be a little bit higher on that first required minimum distribution that you will be taking. So at age 73, it's going to be 4.05% versus 3.91 at age 72, and it was 3.65 back when the starting date was 70 and a half. So that's the new RMD ages. Let's shift gears a little bit and talk about some of the Roth related provisions that we've seen in this bill. There are four key ones. The first is that historically, there's been a little bit of confusion between the rules related to employer-sponsored retirement plans and traditional IRAs or Roth IRAs. So with a Roth employer-sponsored retirement plan, think like a 401k. With a Roth 401k, The rules have been that once you reach the age of 72 and now 73, if you're still working there, you are required to take a minimum distribution from a Roth 401k plan. Well, we all know that with Roth IRAs, you aren't required to do that. So it was kind of a motivating factor for people to move their money out of a Roth 401k and into an IRA. This law has done away with that requirement for employer-sponsored retirement plans, and that's something that I think is going to be valuable and just bring a little bit more congruency in the law. The second point here is that we have seen a creation of simple Roth IRAs and SEP Roth IRAs. Historically, simple IRAs and SEP IRAs only allowed traditional forms of those retirement plans. And in this case, they're creating effectively an entirely new plan with a simple Roth and a SEP Roth. And we'll talk about some of the implications of that in just a second. The third change or factor here is that we now have the ability for employer contributions in employer-sponsored retirement plans, like a 401k, to be made to the Roth side of that 401k. And that's a really valuable thing. Historically, that's only been able to be done to the traditional side of the 401k, and now it will be able to be contributed to the Roth side. And then finally, for any catch-up contributions that you're taking advantage of in a 401k or employer-sponsored retirement plan, if you make over $145,000 in wages through that employer, that catch-up contribution must be contributed to the Roth side of the employer-sponsored retirement plan. So as it relates to financial planning considerations and how this impacts us, pretty straightforward with that first point. We're not going to be required to roll over a 401k, a Roth 401k, to avoid RMDs. But one of the things that we really like about the new SEP IRAs and simple IRAs is it creates a few new lower cost options for small business retirement plans that allow Roths. So for those of you that have worked with us in the past and own a small business, you may have, you've certainly heard us talk about the importance of setting up a retirement plan for your business and the ability that it gives you to save more towards retirement. And if we wanted to take advantage of Roth options, the only solution that we had was the Roth IRA and a solo 401k with a Roth option. Well, this opens up many more, a couple of other options that are much lower cost than a solo 401k and more flexibility than just a Roth IRA. So that's going to be a positive thing going forward. Obviously, we're going to have some Roth versus traditional optionality for employer contributions, and just recognize that if you are making catch-up contributions and you're a high income earner, you are only going to be allowed to put those into the tax-free or Roth portion of the plan. Another point here on the retirement plan side of things, when setting up retirement plans for sole proprietors or single member LLC account or companies, historically, if you were going to set up, say, a solo 401k, you had to have that plan established by the year end, by December 31st of the year you're starting that plan, and have it funded. Well, this is going to allow a little bit more flexibility for business owners in that it's going to extend the establishment deadline and the deadline for deferrals for that first year, not in future years, but for the initial plan year. It's going to defer that to April 15th, tax filing deadline, which is going to be a very valuable thing. Give small business owners the ability to really have additional time to evaluate which plan to use when they're setting up a retirement plan. So I think this is just really going to give us, as your financial advisors and as your advisors in these types of instances, more time and the ability to just be more accurate when we're setting up these retirement plans for you. Let's shift gears a little bit and talk about beneficiary options for spouses. There's an important change here on the spousal beneficiary side of things. You guys may know that when you inherit an IRA or a retirement plan from your spouse, you have a couple of options. And this is specifically related to employer-sponsored retirement plans. So if you inherit this from your spouse, you have the option historically to keep it as an inherited IRA, put it into an inherited IRA, or roll it over to your own IRA. A third option has now been created where you get to be treated as the deceased spouse. And let's talk about how that's a valuable thing. Well, first of all, with the previous options of putting it into an inherited IRA, you had the ability to, if you were older than your spouse that passed away, you could put it into that inherited IRA and delay taking RMDs until the age at which your deceased spouse would have started RMDs. And that was a valuable thing because let's say you were 10 years older than your spouse, you could wait an extra 10 years to take out or to begin taking RMDs than if it was based on your age. The problem was you had to use the single life expectancy table, not the uniform table. And this is the key differentiator here. When we're treated as our spouse, and this is the new option here, you have the ability to kind of keep everything as it is. And when it comes time to take RMDs at the age that your deceased spouse would have been taking RMDs, you can do so using the uniform table for calculating life expectancy at that time. That's really important because if we take a look here at the bottom, let's assume we're a surviving spouse and we're 10 years older than our deceased spouse, and that spouse died at 65. Well, we can delay RMDs under the old rules to the decedent's age 73. But at that time, under the single life expectancy table, the distribution would be almost 11%. Under the new rules, you can delay, same sort of thing for 8 years, but at that time, the RMD rules would be 4.05%. So this is a really valuable thing in that it gives us the ability to make distributions that are a lot smaller than what's historically been available. So again, just giving more options to the spouse and very tax efficient, effective options at that point. Another change that we're seeing, and you'll see this really throughout the presentation today, but the IRS and Congress has really made it a point to begin indexing various contribution amounts and lots of different factors for inflation. And starting in 2024, we will start to see the IRA contribution, catch-up contribution, indexed for inflation. This has been around for a long time. It started out at $500. At one point was kind of arbitrarily raised to $1,000, and it's been at $1,000 for many years now. While the IRA maximum has been indexed for inflation, the catch-up contribution is not. And they're bringing this in line with that. So 2023, it's $1,000. Starting next year and later, it's going to be indexed for inflation. So we should start to see that increase as well. Final point I'll make here before turning it over to Travis to talk about the next sections here. There is a new retirement plan catch-up contribution that's been created. And this is not applicable to IRAs, it's applicable to employer-sponsored retirement plans. Starting in 2025, there is going to be a special catch-up contribution limit for employees who are ages 60 to 63 at 4-year window. And with traditional plans like a 401k plan, 403b plan, those sorts of things, that catch-up contribution is going to be the greater of $10,000 or 150% of the regular catch-up contribution, and that's going to be indexed for inflation. And for simple plans, it's going to be $5,000 or 150% of the regular simple IRA catch-up contribution. So here's a chart that kind of breaks it down. Ages 50 to 59, you have the ability to make a catch-up contribution. Right now, that's $3,500 for the simple IRA and $7,500 for employer-sponsored retirement plans like 401ks, 403bs. Well, for that 4 years between ages 60 and 63, you'll have the ability to make an extra large contribution of $5,000 in case of a simple IRA, or 150% of the $3,500, or $10,000 in the case of a 401k, or 150% of the normal catch-up contribution. Something that's interesting to note, and I think speaks to the inefficiencies of our bureaucratic system, is if you take $7,500 and multiply it by 150%, that's $11,250. So we're already in a position where that $10,000 maximum is moot. So I'm not really sure why they even put that in there, but effectively going forward will be 150% of the normal catch-up contribution going forward. But once you get over age 63, it drops back down to that $3,500 and $7,500 respectively. So from a financial planning consideration standpoint, there are two things that we want you guys to be aware of. One, recognize that if you want to take advantage of this, you've got that tight 4-year window to make additional contributions. And it's really up to you to make sure that you increase your withholding percentage rather significantly to take advantage of that. The second point is remember that this catch-up contribution, even though it's something new that's been created, if you make over $145,000 in wages at that particular employer, your catch-up contribution is going to be required to be put into the Roth side of things. So with that, I'll turn it over to Travis, who will talk to us a little bit here about qualified charitable distributions. Travis, I'll turn it over to you.
So yeah, thanks, Max. The Secure Act adjusted the distribution limit for qualified charitable distributions to be indexed for inflation. For those of you who don't know, a QCD is a distribution from your IRA that goes directly to a charity of your choice and can satisfy your RMD requirement, actually. So while you don't get a charitable deduction for it, the distribution from the IRA isn't treated as taxable income. It's a great tool for those that take RMDs and also contribute to charities, as you can lower your taxable income while still contributing to any charity of your choice. The Secure Act also provides the opportunity for a one-time funding of a split interest entity. Let's see here. A split interest entity essentially involves forming a trust that is split into two components, one being the interest or revenue component. So this is going to be the income that is earned by the trust. And then second is the remainder interest. This is the principal of the trust that remains after the term of the trust is over. What the Secure Act is allowing someone to do is create this split interest trust directly from a QCD distribution. While it sounds great on paper and really cool, it's only currently limited to a $50,000 contribution. And these, trusts, they have a lot of high administration fees. So in most situations, it's not going to be worth the effort. Financial planning considerations from this. Basically, you have a lot more potential relief from RMDs by taking the QCDs. And if the split interest entity option is something, that you're interested in, you can use that to fund, additional retirement funds while also contributing to a charity once the term of the trust is over. The Secure Act also updated a lot of exceptions to accessing your retirement money early. Normally, any early distributions taken prior to age 59.5 would be subject to a 10% penalty. What these exceptions do is provide a way to avoid that 10% penalty by accessing your retirement plan money early. You can see from this list here that the Secure Act added a lot more exceptions. There currently already is a decent list, but these are specifically new ones that have been added. You can see there is a age 50 exception if you are a private sector firefighter, correction officer, public worker, or you've worked 25 or more years in public service. They also created exceptions for individuals with a terminal illness, domestic abuse, if you need the funds to fund long-term care distributions, if you've been in fact impacted by a qualified federal disaster, or a one-time emergency use withdrawal. And just to highlight a couple of these, the qualified disaster distribution is going to function just like the COVID distributions from 2 years ago. I know on the tax side, we had plenty of clients that use these. So it's just going to function exactly like that, where you have a one-time withdrawal, and this is going to be limited to $22,000. You then have the option to spread the income over 3 years. So that $22,000, you can spread the tax impact over 3 years. You also have the option to repay that back at any time. So it could be, in essence, a short-term loan to you from your retirement plan. Another one is the emergency withdrawal exception. It sounds great on paper, but is actually only limited to $1,000. So, while it could be useful for some people, the low amount of the withdrawal is relatively minimal and probably won't provide that much help for too many people. Moving on, if you find yourself in a situation where you need cash, definitely reach out to us. There are a lot of exceptions, beyond the ones we just talked about, that where you can access these retirement funds early and avoid that 10% penalty. The Secure Act also updated, made some changes for individuals with disabilities. The Secure Act changed the eligibility age for ABLE accounts from age 26 to 46. If you're unfamiliar with an ABLE account, it's a tax advantage account for disabled individuals which functions similar to a 529 plan. You can fund the account with after-tax money, and the account will grow tax-free as long as the distributions are used for qualified disability expenses. You can note this doesn't go into effect until 2026. Building on top of that, the Secure Act updated the treatment of disability payments for qualifying first responders. Disabled first responders currently receive disabled payments tax-free until they hit, retirement age, and then those will become taxable. What this does is it makes that portion of the disability payment non-taxable in retirement as well. Similar to the ABLE account, this one has a delayed effective timeline, so it doesn't go into effect until 2027. The Secure Act also updated the treatment of RMD penalties. Previously, there was a 50% penalty for RMD mistakes. The most common one being is, someone forgot to take their RMD, or they took it and it was the incorrect amount. To correct it, you typically have a 50% penalty. So it was very harsh for individuals who were trying to correct it. So basically what the Secure Act did was lessen that penalty from 50% all the way to 10% if the penalty was corrected timely. And it also alleviated or added a statute of limitations for these RMD corrections. Previously, someone that would have an RMD issue, they most likely wouldn't know about it for several years. And so the statute of limitations would never go into effect. And so when they did realize it, they could have missed it for 10 years. The penalties would be very severe. What this does is it attaches that statute of limitations to the actual tax return. So instead of there being an indefinite period of limitation, it's now limited to the tax return, which has a 3-year statute of limitations. Now I'm gonna turn it back over to Josh here.
Thanks, Travis. Okay, so one of the other components of the Secure Act 2.0 is the creation of the new emergency savings account. This is a pretty novel component. What is the new emergency savings account? This is a vehicle that can only be accessed through a employer-sponsored plan, so a 401k or a 403b. So if you want to try to set this up on your own individually, that's not going to be possible. It's only accessible through an employer-sponsored plan. But this allows individuals to contribute to an emergency savings account. The limit that can go into that account, or let me rephrase that, the limit of the balance of that account can only go up to $2,500, although employers will have the option to make that amount lower. And what's unique about that is two things. First, the money that is contributed towards the emergency savings account actually counts as contributions towards the 401k, which means that if your employer has a match, but you're not in a financial position yet to actually contribute to the 401k, you need to save money for, say, an emergency fund. This is a way for you to do both. You can save for an emergency and at the same time still get the employer-sponsored match. Now, some of the rules surrounding this haven't been fully worked out, and we won't probably get full guidance on this until the IRS rolls out some of the rules. But based on how things work, you could theoretically put money into the emergency savings account, withdraw it for an emergency, whatever, and that's not really defined in any way by the IRS, and then continue to fund it until you max out the match that is eligible in an employer-sponsored plan. So we'll have to see exactly what those rules look like, but that's one potential way that could be really used in a big way. Okay, let's go and move on to the 529 plan. So this was another big area that the Secure Act 2.0 addressed. So currently today, 529 plans, which are primarily used for funding college education, is a vehicle that can only be used for educational purposes. A person decides, hey, I want to save money for my child or my grandchild. That money is put into the 529 plan. That money then will grow tax-free. And then as long as it is withdrawn and used for educational expenses for that beneficiary, the child or the grandchild, then the money is distributed tax-free and none of the profits have to be taxed. What the Secure Act does is they actually provide an additional provision for 529 plans, because currently if you have a child that let's say they got a full ride scholarship, so they never needed any of the money for education, you set aside this money for their beneficial use, and now you're left really with two options. You can, in order to maintain the tax favored treatment, you could pass it on to another direct relative, another sibling of the child or another grandchild, or you could take the money out. But if you do that, you lose all of the preferential tax treatment. And so what this provision does is it allows one additional option, which is now the 529 plan could be used as money to help fund a Roth IRA for the beneficial person in this particular example. Now, there are several conditions that are important to be aware of. First, the individual who would be able to use this for their Roth IRA is the actual beneficiary of the 529 plan. The 529 plan is owned by, let's say, the parent or the grandparent, but the beneficiary is the child who was supposed to receive it. So this money could not be used for the parent or the grandparents' Roth IRA contributions, but it could be used for the beneficiary of the 529 plan. Second, the 529 plan must have been opened at least 15 plus years ago. So there's some longer term planning that would need to be had in mind when you're using something like this. Additionally, the contributions to the 529 plan that are less than 5 years old or less, are ineligible to be moved. So if you just opened it up and put $100 in, but then did most of your funding 10 years in, most of the money would be ineligible to be used. The last two major considerations is that all the normal rules surrounding IRA contributions still apply here. The most notable, which is the beneficiary, or the child or grandchild in this case, would have to have earned income in order to be able to contribute. So if you have a child in high school that gets a summer job and they make $6,000, you could contribute $6,000 to their Roth IRA. But if they're in high school and they don't ever get a job and they don't have earned income, you won't be able to move money from the 529 plan over to the IRA. So that's the first normal rule that would apply. And then the second rule is normal contribution limits. This is not money that could be put into the Roth IRA on top of the normal limit. So if you're under the age of 50, or the beneficiary is under the age of 50, the limit today is $6,000 that can go towards their IRA, or in this case, the Roth IRA. And so if they contribute $3,000 to the IRA, the Roth IRA, the most you can contribute is $3,000. So the contribution caps are still in place and have to be considered when you're making those contributions. The last major point here is that there is a lifetime maximum amount that can be contributed to a single beneficiary from a 529 plan, and that is $35,000. So from a financial planning standpoint, how is this really affected? First, this could allow money that was earmarked for educational purposes to be repurposed without losing the tax favored status. And secondly, kind of tying in with this, for some higher net worth families that really would like to kind of prime the retirement pump for children or grandchildren or other loved ones, this could be a good tool to use, as it would allow money to grow tax-free inside of the 529 plan until ultimately they could then move it into the Roth IRA for that particular individual. Would require a lot of forethought and a lot of planning ahead of time to do it well, but definitely a tool that would be worth considering. There was also a bunch of additional annuity related changes. There are a lot of them, but the most important thing that you need to be aware of is the fact that you don't need to know what they are, because at the end of the day, the annuity companies are going to be taking these changes and carrying them into effect. You are going to be the recipient of the outcome of those things. And so we're not going to go into a lot of detail on those today. Now, the other thing that's really important to think through is what is not in this bill. There were a lot of rumors surrounding what was going to be or not included in this bill. So the first area that was talked about a lot was the limiting the use of the backdoor Roth or the mega backdoor Roth. That did not happen. There were absolutely no limitations to this area. Additionally, new limits on who can make Roth conversions was something that was discussed pretty extensively. Also not in the bill. Third, creating non-age-based RMD requirements, such as requiring balances in excess of a specified amount to be distributed. Also not in the bill. Changing the age at which QCDs can be made. As Travis mentioned earlier, this has not been changed. Actually, I think that might have been Max who said that. Fourth, implementing new restrictions on qualified small business stock. Also not in the bill. And then finally, an elimination of certain types of investments from retirement accounts like IRAs, privately held investments most specifically, also not in the bill. So if we really were to take a step back and just look at the bill as a whole, this is actually probably one of the better things that have come out of Congress in some time in terms of what it allows. There's a lot of new things that they allow. There's a lot of congruence that gets added with inflation indexing and some other components. So overall, I would say it's a pretty positive bill. Maybe not necessarily the best written, and there's probably a lot of still ambiguity surrounding certain areas, but overall, the things that it allows us to do will give us more options and tools from a financial planning standpoint. The last thing, and I think this is a really important observation not to miss, is what does this teach us about Congress? First, Congress cares about money today and projections today to fund their spending now. This bill was very much pro-Roth IRA. In some cases, not even pro-Roth IRA, but literally forcing people to use Roth. As we mentioned earlier, the catch-up contributions, if your income is above a certain level, will automatically be Roth, irrespective of if you want that to be the case moving forward. And what this illustrates is that Congress knows that if people put money into Roth, that means there will be more tax revenue today. The other thing is this bill also allows Congressional Budget Office projections for new bills in the future to show higher tax revenue because it's going to be forcing more people to pay their taxes now, as opposed to having it be delayed by it going into an IRA or a normal pre-tax 401k. As a result, there's oftentimes been some stigma and even some fear surrounding, will the IRS or Congress go after Roth IRAs and at some point get rid of them? I think this really reveals, because once again, this was passed by a Democratic Congress, which tends to be more on that side of things in terms of taxation, increasing taxes and those sides of things. And so what we see is that with the attitude, at least that's right now in Washington, it's actually likely that they will continue to push people to use Roth IRAs because it will help with budget deficits today and the projections and looking better moving forward on the future spending bills. So those are the major takeaways that we would have people look at when it comes to what do we learn about Congress. And so with that, we will open up the floor to questions.
I appreciate it, Josh. Thank you for that. At this point, we have one question that's come in, and Lisa stated to us that she, her 89-year-old mother passed away a couple of years ago, and that was in December of 2021, shortly after the Secure Act 1.0 had passed. And she stated that created a lot of confusion for them. And she asked, will the new act require me to take an annual distribution, or will it be changed to the past 10-year rule of withdrawing the balance by the 10th year of the owner's death? And I'll go ahead and take that one because I was kind of talking about RMDs and inherited IRAs earlier. You bring up a very good point there, Lisa. Really what's happened is prior to 2020 and really 2019, when this Secure Act 1.0 was passed, the inherited IRA rules stated that non-spousal beneficiaries could delay RMDs over the course of their lifetime. They could take RMDs once a year over the course of their lifetime. Well, the new regulation said, well, now you have to do it over a 10-year period. And the widely agreed upon perspective was it didn't matter whether the decedent had been taking RMDs or not. You just had to have your money out by the 10th year. You didn't have to take RMDs each year. It just was at the end of the 10 years, your money had to be out. Well, at the end of last year, and really kind of all throughout last year, the IRS was giving overtures that they were going to begin requiring distributions on an annual basis over the course of that 10-year period. And unfortunately, this act didn't speak to that at all. There's still some confusion there, whether you're going to have to take an RMD over the course of that 10-year period each year or not. At this point, the IRS has come out and said 2021 and 2022, if you didn't take an RMD, we're not going to count that against you. We are going to be coming out with regulations in 2023 that will impact 2023 and beyond. So it's still unclear at this point whether you have to take RMDs or not. And unfortunately, we can't give you any clarity on that. That's going to be something that the IRS is going to require us to address. So hopefully that answers your question. If you have any other additional details about that, definitely do give us a call or email us, and we'll get some more specifics on that front. We have one other question that came in, and Josh, I'll direct this to you, and it has to do with 529 plan to Roth conversions. And just really looking for a little bit more detail on how money is eventually moved from a 529 to a Roth IRA and in what amounts. So maybe if we could just step back and review that one more time.
Yeah.
And walk through the details of that. I'll step
Yes.
back to the slide so you can walk through that again.
Yeah, that'd be great. So once again, the normal rules surrounding Roth IRAs still apply when it comes to 529 plans. Really think about it this way. All the 529 plan money is money that is allowed to grow tax-free up until the point that it basically is then used for the contribution. So the participant has to have earned income. And they can't contribute beyond what that earned income amount is. And you can't contribute in addition. So let's just use an example to make it easy. So let's say as an example, for my youngest child, I have a 529 plan that I set up. She gets to high school age, and it looks like for some reason she wants to go to trade school instead of a normal school. So I decided I'm going to use some of this money to help contribute to a Roth IRA for her. If she, let's say, gets a summer job, and let's say she makes $5,000 over the summer, that means from a tax standpoint, the most I can, or that she can contribute to a Roth IRA is $5,000. Let's say she decides to put in $2,000 into a Roth IRA on her own. I am now limited to filling in the excess of what she would be capable of putting in otherwise, which in this case would be another $3,000. So I am then allowed to move $3,000 from the 529 plan over into the Roth IRA, provided all these other conditions were met. The funds that we're moving are 5 years old or older. The account was opened at least 15 years beforehand. So once again, all the same rules, natural rules apply there. Earned income, the same limit applies, and you can't add this contribution in addition to a normal contribution. So hopefully that answers the question there.
Great. Thanks, Josh. Well, that is all the questions that have come in, and we're about at the time that we had allotted for the presentation. So thank you guys again for joining us. We are privileged to help you guys in both the tax side and the wealth side. And if there's anything that we can do for you, please do reach out to us. For those of you that are interested, we have recorded the presentation. We'll be sending out a link to that later this week. So please keep an eye out for that. But again, thank you for your time today, and we look forward to talking to you soon.